Hi, my name is Clare Murray. I'm Managing Partner of CM Murray, and we are a specialist employment, partnership and regulatory firm. And I'm absolutely delighted to be joined today by our specialist SRA partner, Andrew Pavlovic. Hi, Andrew.
Hello.
So we've been getting a lot of questions from clients about the new SRA obligation on lawyers to challenge unfair behaviour. And we just thought it would be nice to have a chat about this, about some of the little knotty issues that are coming up in practice. But maybe, Andrew, you can just kind of set the landscape for us by explaining what is the obligation to challenge unfair behaviour, and also who does it apply to?
So this is a new rule that's been introduced into the Code of Conduct for individuals and firms. The rule talks about treating colleagues fairly and with respect and not bullying or harassing them. And then the obligation, which applies only to managers, is to challenge behaviour that doesn't meet that standard. So to challenge unfair bullying or harassing discriminatory behaviour.
So, and when you say managers, who does that mean?
So the manager would be, for example, in respect of an LLP, it would be the members of the LLP.
Right.
Partnership, it would be the partners. A company, it would be its directors. So the most senior people in an organisation.
But it wouldn't be, for example, the HR director or the HR professionals or someone who just are outside that partner or kind of member slash kind of corporate director type role.
No, that's right.
So what do the SRA mean by unfair behaviour?
Yeah, that's one of the most contentious aspects of this new rule, is trying to understand what unfair behaviour means in a regulatory context. The SRA have made clear that it's not the same thing as unfair behaviour in an employment context, so the sort of thing that might trigger an unfair dismissal claim or an argument about unfair treatment in an employment tribunal. What they're interested in is behaviour which contributes or creates a toxic working environment where individuals might take steps to try and conceal mistakes rather than admit to them. So speaking very rudely or to someone in an open plan office in the presence of other individuals. They have a case study where a partner criticises the firm's trainees in front of clients. That sort of behaviour which is belittling and humiliating and can create an environment where people don't feel that they want to admit to making mistakes or speak up.
Right, so really it's kind of the protection of clients at the heart of it and the delivery of legal services.
Yes, absolutely, because obviously what's been the trigger to this and the guidance that came out last year on workplace environments is cases where usually junior solicitors have acted dishonestly to try and conceal a mistake, and that's obviously led to client loss. And the usual arguments they've made in the tribunal have been that, that they haven't been supported, they weren't in an environment where they felt they could admit to making a mistake. So that's the trigger for all of this, really.
So we've established what sort of behaviours it covers and who this obligation to challenge applies to. What does it actually mean, though, in practice on the ground? What is a partner who's seeing unfair behaviour? What are they supposed to do? What's the expectation?
Yeah, so the SRA says in its guidance that it doesn't prescribe the way that partners and managers should challenge behaviour. It does say that if a partner sees unfair behaviour and they're able to challenge in the moment and it's feasible for them to do so, they should do so. So understanding when it is feasible to intervene immediately is really a challenge presented by this guidance, because it doesn't give any examples. I suppose an example of a case where it might be reasonable to intervene immediately would be in a case of if someone was speaking very rudely or using discriminatory language or was touching someone inappropriately. Perhaps that would be a case where you could intervene immediately because it's so serious. In other cases, it may be possible for you to wait and then challenge the behaviour after the event. And again, the guidance says that the challenge need not be formal, but it must be effective. So that does leave open the possibility of having a quiet word with someone if you think their behaviour has crossed the line. But in either case, whether it's formal or informal, I'm pretty sure that the firms and the managers will want to make sure that any challenge has been documented to demonstrate that they've complied with their own regulatory requirements and to be able to produce evidence to the SRA if there is any further issues with that individual or the behaviour escalates in some way.
Okay, so we've got a few different things to unpack there. So firstly, so in the moment, if you're the partner and you see something happen and you can safely intervene, either by deflecting, removing, specifically intervening. Certainly, I've been in a situation with someone external to our firm where I've gone, I'm sorry, but that's crossing the line. Please, can you stop? And it worked in the moment. And then you sort of remove the person who's the target of it from that situation sort of as quickly as possible. You can also deflect with a bit of humour in the moment, you know, if that's the safest thing to do, but just getting the person who's being subjected to it out of sort of ongoing behaviour, and then sort of speaking to separately to the individual who's you know, you think is being behaving unfairly. And then, as you say, if I'm the partner, sort of documenting it and then sharing it with probably with HR or with the cult. And we've been having a chat about, you know, who should be the receptacle of that information in the first instance, separate, you know, kind of centrally, and then ensuring that they have a hotline to the cult so that they can feed this information up to the cult and feed through trends, etc. as well. But if you feel that you're the partner and you can't actually do anything in the moment, you're saying that the expectation then from the SRA is to, after the event, speak to the partner directly. Or if you can't speak to the partner, what do you do? Because sometimes actually partners can feel equally vulnerable.
Yeah.
What do the SRA expect you to do then?
Yeah, so the alternatives to raising it directly would be to raise with the COLP, raise with perhaps the managing partner, the HR director. So those are three examples given in the guidance of other ways of challenging behaviour beyond challenging in the moment or raising it directly. And as you were just saying, I think firms will probably want to introduce a uniform approach and a degree of consistency. So you don't have one person going off to the COLP, one person going to the HR director, one person going to the managing partner, because obviously there's a risk there of things getting lost.
Yeah.
Equally, it's predicted that this will result in more complaints going up the chain. And if that results in the COLP in particular being inundated, that might not be positive either. So I think your suggestion of maybe HR as the first point of call, but having that very close connection with the COLP is probably the way to go.
So firms to consider having their own internal policy as to what challenging unfair behaviour looks like for them, what their systems and processes are, how they're going to report consistently, and how they're going to document centrally in a way which is compliant with GDPR as well. And also balances, you know, that it is proportionate and balances the interests of the firm, the person who's been subject to this perceived behaviour, and also the individual who's regarded as having taken those unfair steps. And it obviously may well be that, you know, it could result in an investigation, you know, if it's serious. You say that the SRA doesn't prescribe how firms deal with it, and how individuals respond in the moment. So that sounds like there is a potential range of responses, you know, that it could go from a quiet word at one end to actually an investigation into serious issues at the other, with everything, you know, possibly in between. Well, does that sound right to you?
Yes, yeah. So as I say, they say it can be informal, but it must be effective. So you could have a word with someone and see if that works, and obviously, as we say, document it to make sure you've done that. And if it is effective, then there may not be any need for further follow-up. But unfortunately, if the initial intervention isn't effective and the behaviour continues, then obviously you'd have to consider escalating a more formal process. And obviously, you've got the ongoing obligation to self-report potential serious breaches of the regulatory arrangements to the SRA anyway. So this sort of sits alongside that. So you're also going to have to consider whether it's conduct which is serious enough to be self-reported to the SRA in any event.
Mm.
And that's something that firms shouldn't lose sight of when they're thinking about challenging unfair behaviour. They also need to think, okay, is it behaviour that is so unfair that it amounts to a serious breach which needs to be self-reported?
And that's a potential obligation on the firm, on the
And
person
that,
who
yeah,
witnesses it, and also on the individual who's accused.
yeah, and obviously the self-reporting obligation applies to all solicitors, so not just managers.
Yeah.
So yeah, the interaction between those two rules is going to be interesting and something that firms will have to keep in mind. So just to be clear, this is behaviour which in itself might not be serious enough to be reportable to the SRA. It might not be a serious breach. But if it was to continue, it could become a serious breach. So there's already the obligation to intervene or to report serious breaches. This is about lower level behaviour which could rise up and potentially become serious and create that toxic work environment. And that's what this requirement to challenge relates to predominantly.
So it's like an early intervention
Exactly.
to eradicate it sort of proactively. But equally, it might also include the more serious stuff as well.
Yes, yeah.
Got it. Understood. Thank you. And what about prior incidents? So this is a new obligation from the end of April, and the guidance, I think, came out on the 2nd of May. But what about situations where there have been prior incidents and there perhaps hasn't been any sort of formal follow-up, any formal intervention? So do firms now need to be looking backwards and kind of all of a sudden sort of, partners intervening where they know there have been historic issues that haven't been formally addressed?
No, I don't think it involves trawling through the records or anything like that. Obviously, the firms will need to be alive to potential historic issues and the need to challenge things if they occur again, and also training to show, for firms to demonstrate that they're alive to this, and for the relevant partners to be given that clear message that behaviour will be challenged is going to be very important.
So you probably got your wider training for all of the staff, just as a reminder on bullying and harassment, but also sort of specific training for partners on understanding what is and isn't acceptable, and also understanding when and how they should be intervening to challenge unfair behaviour that they see, how that's described, what the reporting routes are, and documenting the routes. Okay, that's really helpful. Thank you. So how would you just kind of encapsulate the key elements of what you think firms and partners should be thinking about?
Yes, I think firms need to have a clear understanding of what unfair behaviour is. They need to have a clear understanding of how it should be challenged. And that involves all the things we've talked about in terms of training and policies to make clear who they go to, what they do, etc. And then just more widely, I think that cultural shift and understanding about how we create a positive working environment and instilling that, I think, is very, really important.
Great, thank you. And I think another big thing that just in practice has come out of our discussions is the importance of basically a really close collaborative relationship developing between HR and the CULP. So there's just information and understanding going backwards and forwards on a regular basis. And those two functions aren't siloed anymore. And certainly we're seeing a lot of firms where the CULP has a much closer sort of relationship and a hotline from HR to CULP, so that they can just keep them in the loop and there are ongoing updates and information so that the CULP can be properly informed and take action when they need to.
Absolutely.
Hey, well, thanks so much. I hope you've enjoyed this. If you have any questions, please do get in touch. Andrew is always very happy to have a sort of a chat, and he's kind of super knowledgeable, super practical as well. So I'd encourage you to get in touch. And thanks again so much for listening. Take care. Bye-bye.